It is 26 minutes to 8 here on Morning Barbados. It's the 1st of September and we are remembering quite a few things this month. But when we invite our lawyer on the line, Verla Tapisa, she always brings something a little bit new. Maybe we can remember it next week. So welcome, Verla.
Good morning to you and good morning, Barbados.
It's a new term not just for students, but it is for the legal fraternity as well.
Correct.
For us laypersons who don't quite understand how it works, break it all down for us. What's happening?
Today, the 1st of September, is a brand new year for the law term. It used to start in October. It will now start in September. And this year in particular, we're starting with a brand new Chief Justice. So welcome to Barbados, because it has been a while since he was here. What I want to talk about this morning, the new, what we call the CPR, the Civil Procedure Rules. They are new, but they've been around for about 2-3 years. We're, from our end, still working through them. Our Chief Justice incoming has made them quite publicly a focus for him in terms of how we work them, because we're still in the teething phase. But to my mind, part of our problem is that we have not had education in the public as to the new rules, and whilst in some cases they are pretty similar to what we had before, there are certain points of divergence that directly impact on the public, on the users of the justice system, and they need to be aware of it.
Well, I was going to ask that. Who cares? How does this impact Ms. Jones from Eagle Hall?
Ms. Jones from Eagle Hall got injured in a car accident. The liability was not accepted, and she will be expected at some point in time to appear in court to deliver her side of the story for the court to make a determination as to whether or not someone ought to pay her damages. So it impacts on Ms. Jones from Eagle Hall in that way. Before, Ms. Jones from Eagle Hall would contract and retain an attorney, and perhaps will never see the courts until such time as she needed to give evidence in court. That has all changed.
So this, in effect, puts you out of business?
It does not put me out of business. It actually has given us a lot more work. Ms. Jones, what happened before, and a lot of clients complained about it. They didn't know what was going on. They didn't know how far the matter was in the system. There are a lot of procedural steps before you actually get to the door of court. And under the old system, the litigants were neither required nor invited to attend. Under the new CPR rules, they're required to attend.
They have to participate in the process.
They have to participate. It puts a lot of onus on the attorneys, because the clients now know exactly what is going on in their matters. They know what the court requires. They know what has to be done to move forward. One of the biggest changes, though, that I am finding that clients are having a little difficulty transitioning through, and that is the new requirement for witness statements. Before you had a case, you turned up in court, you delivered yourself orally, you were subject to cross-examination, and that is what everybody knew about. I want my day in court. The new system, though, requires us as early as possible to put our evidence before the court, and part of that evidence is your oral testimony must now be reduced to writing. This is a little bit more difficult for a litigant to understand, because they're so used to speaking their minds as opposed to writing their thoughts. And it is a completely different shift to giving the judge as much information as possible from early on, so that he too can do his research and be prepared for trial. It is also aimed at narrowing down the scope of a trial. You're no longer expected to bring everything because it's already written. You will focus on the points of divergence between the parties as opposed to the entire story.
Who benefits more from these new civil procedure rules? As we said, the incoming Chief Justice has said this is priority numero uno, making sure that we understand it, employ it, use it to the best of our ability. Who's benefiting from the implementation and the rigorous application of these new rules?
It's funny you should ask that, because we're still waiting to find out the answer to that. We are in
straight from the hip, Verla.
I don't like to waffle. We're at a stage where the attorneys obviously have a lot more work to do, and they have a lot more work to do up front as opposed to nearer to trial. It is a little difficult because you don't always have all of the evidence that you need up front, and you find that you become more involved in the evidence collection process than you were before. I don't think that was anticipated. What that does, of course, is carry up costs for clients.
But doesn't it also, with the increased costs and the increased rigor, doesn't it also increase the possibility for clients to get the verdict that they want?
Well, it is difficult to say that. What it does is make you anticipate a verdict better. A client may come to you with a case that sounds reasonable and sounds like it is one that you can win easily, or at least it has a fighting chance, but then they do not have the evidence to back it up, and you might find that it may well be a case that is better negotiated as opposed to going to court, or it may well be that you have to break the hard news to the client that this may not actually be worth the expense. To the extent that you get to make an informed decision earlier on, it is better for all parties. But because we are still in the teething stages, albeit 3 years on or thereabouts, the jury is still out as to who benefits more. They're designed to benefit the clients more. I'm not certain if they're feeling those benefits as yet, but then having procedure in place is one thing, but we're still working on practice, how we actually put them into practice.
And it begs the question, what was the lead time to implementation? And why does it seem that we're scrambling now on the 1st of September?
I don't want it to seem as though we're scrambling. We are lawyers, so it is in our nature to look for loopholes. Also, it is brand new, so your interpretation may differ from mine. It is the anticipation that there will be some practice directions to put us in a particular way. Even in terms of the form of the documents, even though the form of documents is now more or less set in stone because we now have models in the rules. Just the format is one thing, but what you actually put into them is still being interpreted differently by different attorneys, which is what litigation is. That is what we do. That is our business. And that will always happen with anything new. A new piece of legislation will give rise to some form of litigation or some need for explanation as to how it is expected to work. So we're still in that phase, and I don't think that it is too late to still be in that phase. So I don't want to say we're scrambling. We're still working through the kinks.
I want to get back to you on that, but we do have a caller holding. Welcome to Dale. Good morning.
Good morning.
Good morning. What's your question?
I have a question, not concerning what you're talking about, but let's say a person been raped 14 years ago. I just want to know that you could identify the person, you know exactly who the person is. Is there a statute of limitation on that?
I'm pausing because I wasn't clear on the first part. Did you say a person's been raped 14 years ago? There is a statute of limitations in relation to everything. When it comes to criminal matters, there are two types. If it is a matter, for simplicity in terms of explanation, that will be dealt with in the magistrate's courts, what we call summary, the time limit is 6 months. But matters like rape, which are more serious, the statute of limitations does not end. For a matter like that, and especially if we're dealing with minors, you always have the opportunity to go and make the report. The difficulty comes with a 14-year time lapse and memory of witnesses, whether they're still living. But you must also remember the other factor that you mentioned, and that is that it has now come to light who the person is, and time limits don't start running until you're aware that you have a cause of action in any event. So if it is that you are now aware, then take the steps necessary to make the report to the police and get an action going. But understand that after 14 years it may well be very, very difficult to prosecute.
Can we just tack back now to the matter of the civil procedure rules? You mentioned that now there are going to be written statements as accompanying or instead of the verbal statements. And we have a question from a viewer who wants to know, will attorneys be helping litigants with those statements, given that they're now seen as being a little bit more difficult to prepare and execute?
And this new process contributes to the additional cost that you alluded to.
It does. Let me start from the beginning. It does not replace oral evidence in its entirety. What we are trying to achieve, what the rules are trying to achieve, is that the written statement would replace your initial oral testimony, what we call the evidence in chief, and then you would simply be cross-examined by the other side, and of course then your attorney would have a chance, depending on what comes out from the cross-examination, to re-examine you on that. It is to cut down on court time. However, some attorneys, and I am one of them, are of the opinion that because it is not a sworn document, that it is not testimony in and of itself. The first thing then that would have to be done at trial is that the witness statement be accepted as your testimony, and then you are tendered for cross-examination. The rules do state, though, that you can elaborate on them, so there is the possibility that your witness statement is taken as your evidence, but you are still asked questions to augment and supplement the witness statement before the other side is allowed to ask you any questions. Now, in relation to the last part, attorneys would be remiss if they did not assist their clients with the witness statements. However, the rules specifically state that it is expected to be in the words of the witness. And that then, there's then this dichotomy, because you would not want the witness statement to be full of legal jargon. But at the end of the day, because the litigant, for the most part, comes to law green, they may not be that aware of what is required in order to support their case and their allegations. So the attorney ought to assist, not necessarily create the document for the client to sign, but assist in its creation and the drawing of that document.
Are we ever going to come to the point where we simplify this whole legal process, where there is a form that says, explain what happened, when, where, why, and so I'm not suggesting that there should be no need, you know, for the legal fraternity, but something that could make it much more simpler and less costly for the average Joe?
Interestingly, because the new civil procedure rules were intended to simplify the system and plug some of the holes that the old one had, and to a certain extent it has simplified the system, but we are never going to simplify it to the extent that we render ourselves extinct.